NAFDAC or Standard Organization of Nigeria. Then so yes, sorry again, network problem. So procedure and documents to be submitted to CAC for registration of business name. I said there is business name. Under CAMA, we have business name, we have company, and we have incorporated trustee. So if you want to if you're running a business, let's say a sole proprietorship or any business, and you don't want to register a company, you want to register a business. If you don't want to register a company, the alternative is business. You can register. You can have proprietors, more than one proprietor in that business. So the first thing you need to do after you've gotten a name, a suitable name, easy to pronounce name, you submit the name for registration on CAC portal. There's something you need to know about CAC portal. CAC portal can either be accessed by accredited agents. And who are the accredited agents? These are chartered accountants, lawyers, and chartered secretaries. These are accredited agents with CAC. So these are people that are registered to be accredited agents. For you to be an accredited agent with CAC, you have to be either a lawyer, chartered accountant, or chartered secretary. So once you register with CAC, you have access to that portal. And lately, they've introduced a whereby if you are a proprietor, too, you can create a like a page or something. You can create a profile where you can access the portal as the proprietor of that business. That means you are registering as the proprietor of the business. So the options are available to you if you want to register with CAC. Either you use an accredited agent or you do it yourself. But the doing it yourself is not going to be easy because you are born to make mistakes, especially with something you are not aware of. But once you use an accredited agent, it's going to be easy for you. So once you access the portal, the first thing you need to do is to submit that name that you've chosen as your business name to CAC for approval. So that name, let me use Mr. Johnson, for example. Mr. Johnson chooses Johnson Ventures. And Johnson Ventures is the name he chooses for his business name. He will submit that business name on his CAC portal to or through an accredited agent. So he's going to submit same. So once he submits the name, CAC will look at the name. And for CAC to approve a name, there are some criteria we look at. Is the name similar? Is the name restricted? Is the name is it a restricted name? Is the name already in use? If the name is a restricted name in the sense that the name has connotation with either Abuja or a state or any municipal. So for you to use that any restricted name, you have to obtain the consent of that particular municipal or state or anything. Let's say Mr. Johnson wants to use Johnson Ventures, Johnson Abuja Ventures. Because of the word Abuja there, restricted. So once CAC are sure that the name is not similar, the name is not in use, the name is not restricted, that has been approved. If it has not been approved, they will tell you it has been approved and they will give you reasons for doing such. So once the name has been approved, you proceed to application. The approval note will contain your code, the code you use in your registration. So you proceed to your registration, you state the name of the business, you state the name of the business, the nature of the business, who the proprietor is. You submit either your national identity card or driver license, voter's card, international passport, or any of nationally recognized means of identification that you have, where you enter the information in the application online. Then after you fill the form, you download the form, then you sign, you attach your two size photographs. You cannot even download the form without paying. So you pay your fees, download the form. Then after downloading the form, you sign. After signing the document, CAC will tell you if there is no query, if your application is not queried, CAC will approve the name and you get your certificate. So examples of business names are Tire and Tire and Co. Global Ventures Fund. So these are examples of business names.
Okay. Sorry, I apologize once more. We're experiencing some technical hitches, and it's as a result of network. So sorry for that interruption. I'm really sorry for that. So, as I was saying, on registration of business name, uh, I was speaking on examples of business name, which we have Tayo and Co and the rest. So now we look at that of company. We look at we look at that of company. What are the documents we need to submit for companies? So similar to business name, a company, we talked about the fact that companies have legal personality. So companies are of different types. We have the private limited company, the public limited company. We have company limited by guarantee. Then we have unlimited company. So, but for the purpose of this class and for the purpose of what we are doing, we are going to discuss only private limited company and the public limited company. For private limited company, you have to, for now, even though the newcomer has brought in changes, the newcomer says you can have one shareholder, you can have one director, but CAC has not started implementing the newcomer. They are still making use of the old camera. So because CAC are still using the old camera, we will still go by the old camera in discussing this particular topic, which is procedure and documents submitted to CAC for registration of company. Because once you enter the portal, once you enter your portal, you will see already, if you don't impute at least two directors and at least two shareholders, you cannot proceed with your registration. So that is how it is for now. So when there are changes, we'll also make changes to our note. So you see, with unlimited company, you can have two to more than uh, to unlimited numbers of shareholders, unlike private limited company where it's 2 to 50. Then public limited are usually quoted at the stock exchange market and are highly regulated by Securities and Exchange Commission. So for if you want to operate a very small company, if you want to operate a small company, it's suitable you run a private limited company. A private limited company is more suitable for a small company. But if you want to run a big company, you need to run a public limited company. But the fact that you begin with a private limited company doesn't mean you cannot operate same private limited company to a public limited company. You can do that vice versa. But for the purpose of starting a small company, it's more suitable you start with a private limited company. So just like business name, the first, so if you've determined which you want to register, is it private limited company or public limited companies, you get a suitable name, just like uh, just like the business name we talked about earlier. You get a suitable name which you will submit to CAC, and CAC will consider all the criteria for approval of name. Is it restricted? Is it similar? Is it in use? If it does not fall into any of this, if the name you submitted to CAC does not fall to any of these categories, then CAC will approve the name and they will send it to you. After approval, says there's a code that will be given to you on the approval notes. And on the approval notes, you enter the code, then you begin your registration. You fill all incorporation documents with details of personal information of the directors and the rest, with photocopy of the information page, either national identity card, driver's license, voter's card. You attach all to CAC after you've filled the form online, because everything you do you fill it online. You fill the forms online with your details, the number of directors, at least two shareholders, at least two, then the object of the company, the articles of association. You are going to fill all these things. When we talk of memorandum and articles of association, we are talking, when we say memorandum, we are talking of, these are what are the objects of the company, how the company will what regulates the companies with individual outside of the companies, with other artificial and natural persons outside of the company. When we talk of articles of association, we're talking of the rules that regulate the company within that. These are the rules that regulate the company. So once you fill in the information online on your portal, the next thing to do is you download the forms. You make payment to CAC. The payment is registration fee, stamp duty, even the reservation of name, and you have to pay for the reservation of name too. So the after filling the form, you also pay for your registration fee and stamp duty. You pay stamp duty to Federal Inland Revenue Service. Then you download your forms, you sign, you attach all the photocopies of documents you already uploaded to CAC. You attach them, then you upload your documents back to CAC, then you submit same. After submitting, CAC will look at your application. If your application is normal, they will not query it. Then you go on, and the company will be approved. The company will be approved and your certificate given to you. So where you can't do it yourself, get an agent. A lawyer is always there to help you with your registration, or a charter secretary who has CC portal to help you with the registration. Then fee for registration of company under, this is just for the purpose of this class, because things concerning to fees and all these things are subject to policy, something they can change at any time. So this one is just for the purpose of this class. So don't bother looking at those fees. By the time you contact an accredited agent, he will give you the figures that are being charged now and the rest. So we'll quickly look at the law of contract. So when we talk of contract, we are talking about enforceable legal obligations agreed upon. So for there to be a contract, then it must be enforceable and it must be legal obligation. There must be nothing illegal regarding that contract. So once there are illegal anything associated to that contract, it becomes void and null from the onset. So what are the elements of a valid contract? The first basic three elements in a contract are offer, acceptance, and consideration. When we say offer, is you making an offer to someone that you want to sell, maybe you want to sell a car. You approach the person and say, I want to sell my BMW car to you. That is you making an offer to the person. But where there are situations where offer can be in another way, unlike always somebody approaching somebody. Example is when you go to supermarkets and when you want to enter a taxi. In such scenarios, is the taxi that are making offer to you. Though you are standing on the road, in law, what we call that is invitation to treat. So once the taxi stops, that's the taxi making offer to you. You entering now is acceptance. So if you offer your BMW to Mr. Uh, Mr. Johnson, Mr. Johnson agrees to buy the BMW, that is acceptance. Contract is not yet completed. There must be what we call consideration. That is, there must be exchange, something of value must change hands. So that once you pay money, then we can say in law there is a valid contract. So these are the three first basic elements in a contract: offer, acceptance, consideration. So offer form, when we talk of form of contract, contract can be either oral, written, or it could be by conduct. In the oral, in the sense that parties agree orally. Because for instance, if you want to enter a taxi, just normal things we do every day. You go to market, you buy a product in a bookshop or in normal kiosks. These are contracts you are entering with such people, even though they are very small contracts, but you are entering into an oral contract with such a person. Contract by conduct, the best example I can use for you is taxi. When you stop by the road, let's say you are coming from, we say you want to go to Bergen. When you stop at the road, that's invitation to trade. Once the taxi man stops, that's an offer. Some people will not even talk because they will just enter the taxi because they already know that this is the route the taxi is taking. So they will just enter the taxi and they already know the amount. Once they've reached their destination, they will tell the taxi man, oh yeah, stop. They will pay the taxi man. So that contract entirely is by conduct. Then we have contracts which are written. That contract is written, that means it's in writing. Parties have reduced it in writing. So these are form. Then when we talk about capacity, that means for you to enter into a contract, you must enter into a contract with somebody who has the capacity to enter that contract. One, he must be of the age. Two, he must be of good mental state when he entered the contract, and he must not be drunk. So, so these are some of the capacity they will consider when you enter into a contract with a person. When you enter a contract with a child, you know that is underage. Even though in Nigeria we don't have a specific age that says this is the age of um, uh, which will consider somebody as that particular person has matured or a child has matured. But going by election, which is 18 years, we can say when you enter into a contract with somebody who is under the age of 18, that contract, there's possibility of that contract being void for you've entered a contract with someone who does not have the capacity to enter into a contract. But there are exceptions to that. If you enter a contract with somebody who is underage to enter into a contract, where the contract is of necessities, that is things that are of necessity to that person who is underage, such contracts are legal. So this is it about capacity. Also, when you enter a contract with a mentally challenged person, that contract too is void, except when that person in his lucid state, if his own mental problem has lucid state, that those states in which he's of sound mind, then that contract can said to be uh, uh, that contract can set to be legal. And legality, everything we've been talking about in terms of capacity form, especially in terms of capacity, has to do with the legality of the contract. You cannot enter into an illegal contract and you want to enforce such contract. It's not possible. You can't enter into uh, an illegal contract and say such contract is enforceable. For instance, when a prostitute enters into a contract with a customer and the customer fails to pay her money, she cannot sue that person because that contract ab initio is illegal. And there must be an intention to create legal obligation. There must be an intention between the parties to to create uh, to create a legal obligation. So parties must be always willing on their own to enter into contract for such contract to be considered legal. So these are just the features of a valid contract. Then the next under this law of contract, the next subtopic we are going to look into is privity of contract. What is privity of contract? When we say privity of contract, we are just simply saying only parties to a contract can enter into that contract. Where Mr. Johnson and Mr. John enters into a contract, the persons the persons that can sue where there is a breach of that contract is only Mr. Johnson or Mr. John. For instance, Mr. Johnson wants to sell his BMW to Mr. Johnson and to Mr. John, and Mr. Johnson is in breach of that contract. Mr. Johnson is quite sure sold the car to Mr. John, but contrary to their terms of contract, the engine wasn't in a good and proper condition. So in that case, only Mr. John can sue Mr. Johnson. That is privity of contract. The wife to Mr. John cannot sue Mr. Johnson because she was never a party to that contract. But that is just the general rule in law. There is an exception to that, which exception is when it comes to estate covenants. That is issues of estate where somebody buys you are living in an estate and the estate management has or the property developer has a rule or has laws which you are to abide to as a resident in that estate, and Mr. Johnson, who bought the property from the property developer, decided to sell it to Mr. John. And Mr. John, on the other hand, after buying the property from Mr. Johnson, decided to erect the fence, even though they said the fence should not be more than certain centimeters, decided to erect the fence to a certain centimeter. In such a case, uh, the estate management can, or the property developer, even though he's not a party to the contract between Mr. Johnson and Mr. John, he can sue. So this is an exception to the general rule in privity of contract law. Where if you are not a party, you cannot be, yeah, you cannot sue in that particular contract. Then, in terms of contracts can be expressed. That is when you are agreeing, the express terms, that is, it's written, especially in a written contract. All the terms are written clearly for parties to see that this is what we are entering to. It's not for parties to go and import one term and bring it, or it's expressed for parties to see that this is what we are going into. It's expressed, the terms are expressly stated. But sometimes certain terms can be implied too. If you are buying a phone from somebody, definitely you expect the phone to be in a good working condition, even though it might not be stated expressly, but you expect the speaker to be working properly. If there are some apps, like let's say WhatsApp, let's say, okay, the home button and the rest, even though it's not expressly stated in the agreement that all these things must work, there is a term that can be implied to. But in when it comes to law, rarely will courts imply term into a contract between two parties. So the next thing is we're going to talk about vitiating elements in the contract. What can vitiate a contract? One of such is duress. When we talk of duress can be actual threat of physical violence on somebody, or economic threat. You are threatening that person with violence, that if you don't do such thing, I'm going to if you don't enter into this contract, I'm going to murder your family or something. That's duress. You are making the person to enter into that contract with duress. You are asking he must enter this contract. If not, there are consequences. So such contracts cannot be considered to be valid. Undue influence, in the sense that undue influence can exist where there is a special relationship and where there is no special relationship. Where there is a special relationship, let's say a daughter and a stepdaughter and a stepmother, she influenced the stepdaughter to take a decision. Because of that fiduciary relationship that exists between her, such contracts will be vitiated, especially because there is an undue influence, or where there is no special relationship, but you are making a party because you have an influence over that party due to a transaction the party conducted, and you know of the transaction. Then you tell the party that, okay, Mr. John, if you don't enter into this contract now, that thing you did the other day, I'm going to report it to the authorities. That is you using undue influence on that person because you have knowledge of something that you will influence him with. So in such a case, such contracts are not valid. Or where another instance where a contract will not be valid is when you misrepresent facts. When you misrepresent facts at the time of the contract or before entering the contract, in such a case, the contract would not be considered to be valid, rather it will be invalid. So where there is also mistake too can vitiate a contract. Mistake, in the sense that mistake can be common, it can be common mistake, it can be mutual mistake, it can be unilateral mistakes. When we say mistake in law, common mistake, it exists where, let's say, parties, Mr. John and Mr. Johnson, for instance, are discussing to sell a filling station in Gwagwalada. Unknown to them, in the course of that discussion, the filling station in Gwagwalada has been destroyed by storm. So in such a case, that contract is not valid, even though at the time they've concluded everything, they've concluded payment. But because the rest, the subject matter of the contract is no longer in existence, that contract is no longer in exist, is vitiated, is no longer valid. Another instance of mistake, which we consider as mutual mistakes. Let's say Mr. Johnson has two cars, a BMW and Mercedes Benz. Then he told Mr. John that I'm going to sell my Mercedes for you for 50,000. Then I'll sell the BMW for you for 40,000. Mr. John thought Mr. Johnson will sell the Mercedes and BMW for 50,000 naira, not knowing that the Mercedes is going for 50,000 naira, the BMW is going for 40,000. Even if the contract has been concluded, but due to such mistake on the part, mutual mistake on the part of both parties, then that contract is vitiated. Then we'll talk about discharge of contract. How can contracts be discharged? One, contract can be discharged by performance, where parties have performed their part of the contract. Such contract is set to be discharged, where Mr. Johnson entered into a supply of 5 trucks of beans to Mr. John. Once he supplies that 5 trucks of beans, that contract has been discharged by performance. We have frustration, like in the case of mutual mistake, where parties were negotiating for the sale of a filling station in Gwagwalada, not knowing that the subject matter of the contract is no longer in existence. In such a case, that contract will set to be frustrated, and parties will be discharged. Where there is a fundamental breach to the term of the contract, where Mr. John is asking for Mercedes for Mr. John says Mr. Johnson is supplies car, and Mr. John told Mr. Johnson to supply him with a Mercedes Benz. Then Mr. Johnson went and supplied a BMW. That's a fundamental breach to the term of the contract, because what Mr. John is asking for is a Mercedes, not BMW. So in such a case, there's a fundamental breach of the contract. Even if he has made payment, that contract is null and void, is invalid. And parties can decide to end a contract by mutual agreement, where they will, even though they've not performed their various obligations in the contract, they will decide to say, okay, uh, we don't want to go ahead with the contract for various reasons. So in that case, they can discharge. And finally, which is the last subtopic under the law of contract, or topic we will be looking under the law, is remedies for breach of contract. What are the remedies available to you when you enter into a contract with somebody and that person breaches that contract? One of such remedies is damages. Damages is monetary compensation, which is being paid to a party who suffers any psychological or any loss as a result of breach of that, any monetary loss as a result of breach of that contract. So damages will be paid to you in monetary terms. Then we have specific performance. Specific performance is saying you are telling the court that you want that other party to perform his own part of the contract. You have performed your own part of the contract, and now you are now telling the court that that other party too must perform his own part of the contract. So that is specific performance. And specific performance is an equitable remedy, unlike damages, which is a law we say is a common law. Specific performance is an equitable remedy, and you are telling the court that you want the court to make a party to perform his own obligation of the contract where you have performed your own. Injunction is restraining a party from carrying out something. That means you are telling the court to give you the remedy of stopping this person from doing this contract, or you've the person, let's say the person is supposed to supply something on 30th day of August, and he went, or sorry, let me use this example. You entered into contract with somebody to be supplying you bag of beans for a certain period of time. The contract has, instead of supplying you good bag of beans as agreed in the contract, he's supplying you bad ones. You can go to court to tell the court to restrain that person from continue on with this contract. That means you are telling the court to tell that person to stop. Another remedy is quantum merit. Quantum merit is according to the value of service. That means is reasonable value of service which the person has offered is entitled to to remedies for that damages, for compensation for that services he has offered you. A good example would be a taxi driver that is carrying you from Wuse to Jabi. Let's say his car spoils at Beggar. Is on in law, the court, what the court will do, they will say, okay, the taxi driver is entitled to his money from Wuse to Beggar. If it is 100 naira, because he has offered you a reasonable service from, even though he has not completed his contract, which is to take you to Jabi, but he took you to Beggar. So because of that, he's entitled to such amount. Then rescission is a situation where the court will rescind the contract totally. That means the contract will not go on. The contract cannot go on. So the court will say, okay, the party will approach the court that he doesn't want the contract to go on. So the court will declare such contract null and void. So that is it for today's class. I want to once more apologize for the technical hitches we've been experiencing due to this network problem. It's because of the network problem that our time extended to this. So if you have any question, observation, or any clarification you want, this is the time to do so. But we'll take limited question and clarification because we've exhausted our time. So you can unmute yourself and ask any question you want to ask, or you want to make any observation, or you want to raise anything. So this is the time to do that. You unmute yourself and you ask your question. So this is the time for questions, clarification, observation. If you want to make any addition to what I've said, okay, Mr. Daniel, you can unmute yourself. Unmute yourself and ask your question. Unmute your mic and ask your question. Okay, you can go ahead now.
Thank you very much for the lecture.
You're welcome, sir.
Personally, I enjoyed it. Keep it short. But I want to just ask just one question.
Yes, sir.
And when you talked about sole proprietorship, partnership, yes. And so let me limit myself on sole proprietorship and partnership.
Okay, sir.
Please, I want you to shed more light. I want you to shed more light on the difference between a sole proprietor. Are you hearing me?
A sole proprietor. I didn't get. Hello? I get you when you said sole proprietor, but I didn't get anything you said Hello? After that. Hello, I can hear you.
The difference between, yes, shed more light on the difference between a sole proprietor, right, and partnership.
Yes, sir. A sole proprietor, you are saying you are running the business alone. Alone. Partnership is where two or more people come together and said, we want to run this business together. You know, sole, as the name implies, sole, one person. You take the decision alone. You enjoy the benefits of the business alone. There's nobody to say, okay, I want, I need to consult with my partner. But when you are running partnership, any decision you have to take, especially general, if you are running a general partnership, you need to consult with your partners. You share the profit together, unlike sole proprietorship, where you enjoy the profit alone. In partnership, you have to share the profits together with your partners. That's why, as the name implies, partnership. You can't be alone, unlike sole. Sole partner. You, for instance, and your wife are partners. So let's say you are partners in the business. But one thing I said about partnership is that for that to be regarded in law as partnership, the profit has to be shared equally. So sole proprietorship, you are the only one. Partnership, you and some people are running the business together and you take the decisions together. So that is the difference between sole proprietorship and partnership. But the one thing I said, the implication of sole proprietorship is that your liabilities are unlimited. Same applies to general partnership. When two or more persons decide to run general partnership, they are actively involved in the running of the business. It's not just one partner saying, I just want to invest. Then in such a case, that partnership is said to be general partnership. And in such a case, partners are liabilities are unlimited. I hope.
Let me also find out. Let me also find out what makes decision of partnership binding. For example, in sole proprietorship, it is sold as the name implies. You take the profit and you take decisions. But during registration at CAC,
sorry, let me interrupt.
What
I
are
can't
those
hear you.
requirements
Hello?
to register a partnership?
I can't hear you. Your network keeps breaking. I can't hear you. I can't hear you.
And it's clear from my end.
Your network is bad. Okay, you
Okay,
can use
so
the chat
let me
if you
return to
want
chat.
to.
Let me send it in form of chat.
Okay. While you are typing the
Let
chat.
me send the message.
Okay, while you are typing the chat.
Yes, let me do that now.
If anybody has a question to ask before we attend back to Mr. Daniel, or any observation or any contribution he wants to make. There will be a quiz after this class. So let's just wait for Mr. Daniel's questions. After the question, then they'll round up the class, then your quiz. Okay. Okay, there will also be closing remarks by the coordinator, then announcement. Okay. Mr. Daniel, we're waiting for your question.
The chat.
Okay. Okay, what are the requirements for registration of partnership in CAC? Well, there is no requirement for registration. You can't register partnership under this present KAMA at CAC. What you can do now is, if you want to register a business name, let's say you want then the partners in the business can be proprietors. You get it? They are the proprietors of the business, but you guys are into partnership. Or you can decide to incorporate a company, then you do a partnership agreement aside, then you make the partners shareholders and directors of the company. But you cannot go to CAC now and say, I want to register partnership. There's no provision for that under KAMA. This present KAMA, that the last amended KAMA, what we have is business name, companies, and incorporated trustee. Or you incorporated trustees for NGOs. So you cannot approach CAC and say, I want to register a partnership. I don't know whether you understand what I'm saying. What you can do at best is for you to draft a partnership agreement. Then you either register that business you want to go into with your partners, either as a business name or a company. Mr. Daniel, are you getting me? So you cannot approach CAC. There is no provision for that I want to register partnership in CAC. But under the amended CAMA, there is what we call limited liability partnership, which CAC have not are yet to implement that. So I guess once they start implementing, they will introduce provision for that. But as for now, you cannot approach CAC and say you want to register partnership. You can either register that partnership, you can have it as an agreement and register either as a business name, company, or depending on your object or incorporated trustee. Thank you. Thank you very much. So,
Hello. Hello.
Yes, sir.
My name is Oyewole.
Yes, sir.
There are some cases
Very
where
well.
you have. There are some cases where you have some people, they register their businesses. They just write so investment. Maybe IO and so something investment. They just put it like that. The limited will not be there.
Well,
So,
now, okay, let me allow you to finish.
Yes.
Okay.
So I don't know how what is the difference between this and maybe those ones that are limited.
Right.
Then sometimes they even say that probably if you have registered the name, probably you just put ordinary business, investments like that. And if you want to limit it can later also be converted to limited. So I don't know
what you said.
Yes.
Regarding that, you see, says if you want to register a company, especially a limited company, if you don't indicate as you are entering the company's name,
yes,
if it is a private limited company, as you are entering the company's name, if you don't put limited, you can't even proceed with the registration on their portal. You can't even proceed with the registration. So if anybody is putting investment in something, that is registering a business name. And the fact that you register a business, you start with a business name, does not mean you cannot upgrade it to a private limited company. You can also upgrade it subsequently. But if you want to register a private limited company now on CAC portal, if you fail to include limited, once you are submitting the name for reservation, CAC will not even reserve that name for you.
Okay.
That is it. So if you tend to register a company, it has to end with either limited.
Okay. So
it has to end.
It doesn't depend or never lie on the number of shares that can be processed there or whatever.
That is, if you want to register the company, the minimum share capital CAC will allow is 1 million share capital. If it is a company you want to register, and there are some companies like Bureau de Change and the rest that says microfinance bank, there are minimum share capital that you will have to register with. But for the purpose of this class, we know that you want to start a family business. What you will do will not be more than a private limited company. And the minimum share capital that CAC will allow is 1 million share capital. 1 million share capital, which you share it into, if you have shareholders, if it is you and your wife can take 500,000 ordinary shares, you can take 500,000 ordinary shares. That is company. But if it is a business name, you don't even need shares because there is not provisions for shares in business name or incorporated trustee. It's when you want to register a company that you have that provisions for that shares. So that is it. Thank you, sir.
Thank you, sir. Thank you.
You're welcome.
Yes.
So in the absence of any question, there will be a quiz and our coordinator will give his closing remarks and announcement. So I'm going to hand you over to our coordinator for the closing remarks. Thank you very much. His mic is
Right. Thank you very much, Barrister Johanna. We appreciate the presentation this afternoon, and I believe that our participants are better enlightened today with all of the discussions we've had. Let us show some appreciation to our facilitator by giving me a round of applause, please. Thank you very much. I appreciate it a lot. Yeah, so we have come to the end of our 5 days training. It's been quite an exciting week, I must say. And yours is one of those most exciting classes. Last week was a little bit one way, but yours definitely was very, very inspiring. And I must say that we enjoyed having you for this entire week. We have come to the end, as I said, but then we are not done yet. We are having our graduation ceremony tomorrow. We normally carry out graduations. It's not physical graduation the way that you are familiar with academic gowns and things like that. It's going to be online. It's not going to cost. Yeah, it's not. No, you don't have to wear any academic gown. There's no academic gown for you. It's going to be online, and it's not going to be through Zoom as we are having this one. We're just going to send some speeches on our platform and to show appreciation. And then, of course, to inform you that we are going to throw open this platform, the Batch 14 platform, for you from tomorrow up to Monday, so that those of you who are already into some entrepreneurial activities, who want to exhibit your products, will have the opportunity to go ahead and exhibit your products, so that you'll be able to market yourself and show us your colleagues the kind of businesses that you do. They will help you to be marketers. They will pass your products across to their other colleagues, and you can be sure that you'll be getting phone calls from them, making orders from the things that you're already producing. So that is why we normally throw our platform open for such interaction, for exhibition, and for trading and marketing, and then exposing more of your products along the line. Then, of course, we have sent out forms for completion. That's the questionnaire, and then the loans forms. We train between batches 1 to 12. They have all been given the approval to come for interview. Okay, we have been following up on their behalf, and they've all been invited to come for interview. So if you are able to also complete your own forms in good time, return it for us to produce a business plan. We will help you do that. And those of you who were not consulting for business plan, I will advise that you also quickly do that so that you also be attended to as early as possible. That's the advice that we'll give, okay? So please have that at the back of your mind, and then try to complete the forms and return them as early as possible. I've already received that of Kefe Abone. She's been very, very proactive. In fact, this is the first time I've seen anybody produce their own documents, what process, and as clear as possible, really. I can't commend her enough. That's been quite proactive. So if others will take a clue from her, I'm sure it will help us a lot here. All right. Having said that, tomorrow we'll be distributing your certificates. Immediately after the convocation ceremony, the graduation ceremony, we'll start distributing your certificates. Okay, you have all your certificates with you. There is a component of the form where your training identification numbers I discussed with you yesterday will be requested. You get that identification number from your certificates to complete. If you are already sent yours down, we'll help you do that, complete that portion of the certificate. But that's basically all we'll have to do with you. So on this note, let me once again, on behalf of the management of Cedron Nigeria Limited, thank you all immensely. Thank you immensely for being a part of our company, for being a part of our class. And if you enjoyed this week with us, we also ask that you recommend your friends to come train with us also, because there are a lot of promises here. We'll continue to be as professional as possible. I'm sure you enjoyed all our facilitators and providing enough cost to also recommend us down the line. Thank you very much. Have a wonderful week ahead of you. Hope we'll continue to interact. The platform will be open for us to continue to interact and engage with you. If you have any problems, any questions, any thing that you want, clarifications that you want, we'll be there to assist you. Thank you. I appreciate it a lot. Bye-bye now. Right. Thank you. Right. Thank you.